Right, it's another day to talk about the administration of criminal justice law. Yes, this is Flow 94.9 FM, the Flow of God's Own State. It's another Tuesday, and this is Wheel of Justice. My name is Ifeanyi Awa, and this program tends to break down different parts of the Acjl, and hopefully we can all get a good understanding of what this is at the end of the day. Now, this program is brought to you by the Abia State Administration of Criminal Justice Monitoring Committee and Prisoners Rehabilitation and Welfare Action PRAWA, with the support of the Open Society Initiative for West Africa, OSIWA, and the Abia State Justice Reform Team. This week on the program, we'll be looking at advancing access to justice in Abia State through first information reports under Part 12-14 of the Acjl 2017. Without wasting any more time, I'd love to introduce my guest for today. He is the chairman, Nigerian Bar Association, Isialangwa branch. I'm talking about Barrister B.E. Onwachukwu. Welcome to our studios.
Thank you.
All right. Now, we're going to have to go straight because we have lots of things to cover on this particular edition of the program, just so we have a better understanding of what we're talking about. And first of all, before we go into any other part of this, I'd like to get a good understanding of what first information report is.
Well, the first information report, as you can see from the law, that is the Abia State Criminal Justice Law of Abia State 2017. Is talking about a situation where reports, these first information reports are naturally made before the police.
Okay.
Yes, and you look at our local scenario here, the people would normally go to police to report cases of commission of crimes.
All right.
Yes.
Now, I understand that before we jump in, normally we're going to deal a lot on the first information part of the law. Yes. But before we go into that part, we need to go to institution of proceedings, deal a little bit of that, then come back to first information.
Yes. First information report is talking about part 13, and that is precisely, we're talking about section 110 of the said law. That's the Criminal Justice Law of Abia State 2017. Then, if we go back to institution of criminal proceedings, we go back to part 12. And part 12 is talking with these sections 107 to 109 of the said law. And it has tried to tell us the different ways in which we can institute criminal proceedings in our courts, particularly within Abia State.
Now, for those who know, sometimes we'll try to break this words down, English down, so that everyone can understand it. When we talk about institution of proceedings, what exactly do we mean?
Institution is how to commencement of criminal proceedings in our courts.
Okay.
How do you start it?
All right.
How can somebody be taken to court and tried for an offense committed?
I know there are 5 methods of starting off these criminal proceedings.
Yes.
So, can we know the 5 of them?
Well, the 5 of them is talking about when regarding institution of criminal proceedings. Yeah, we talk about where a magistrate in a magistrate court is come by way of charge or complaint. We're talking about section 207A. That is where a charge is either by way of a charge or complaint.
Okay.
Charge or complaint. Then section B is talking about high court by way of information of the Attorney General. The Attorney General of the state can file an information or also charge, whether it is on oath or not.
Okay.
Yes. Then we also have a defendant committing perjury before a court, and it can also come by either by way of a charge or information too.
Okay.
Before that particular court. Then we have information of a private prosecutor.
Okay.
A private prosecutor. That is the 4th one. Then the 5th one, we have prosecution, charge or information filed by prosecutorial authorities. When I mean by prosecutor, I'm talking about we have EFCC, we have NDLEA, and we have such a, even which is this other one. That's all of them. These other law enforcement agencies, even DSS.
Okay.
They can prosecute cases.
So basically, the 5 methods are showing the different ways individuals or entities that can start off a legal case.
Yes.
Okay. Now, I also know we have the mode of instituting criminal proceedings in the magistrate court.
Yes.
Let's talk a bit about that. Then we'll talk about the returns by Controller General of Prison before we go over to the first information report.
You mean
that's the mode of instituting criminal proceedings?
Well, the mode is going to be like either
that's in the magistrate court.
Okay, in the magistrate court.
Yes.
Yes, it's got to be either by bringing a suspect before the court, by way of charge, or by way of complaint.
Okay.
Yes, and we have is either a suspect is brought before the court, as in bringing a suspect before the court. That's upon arraignment, or there is a complaint against that person. It's either that person is brought directly, as in bringing him as a person physically to court, or there is a complaint against that person before. I think these are the two major modes in which somebody can be brought before a court.
Now, in terms of returns by the Controller General of Prisons, what does this law say about that?
Well, the law, the Controller General, before then, you look at even the courts ordinarily are supposed to make returns, quarterly returns to the CJ.
That is when we say returns, we mean reporting back.
Reporting back.
Okay.
That's the kind of, and that one is going to carry the totality of all the criminal proceedings within a particular court. And every court is expected to do that within quarterly. Quarterly. That is within a specific.
That is about 90 days.
90 days, yes. You do that, and that will inform the Acjl monitoring committee on how to carry on their duty vis-a-vis the oversight function of the CJ. The Controller General of Prisons is mandated by this law to make returns to the Chief Judge of the state quarterly too. It's going to be within 90 days. Make your returns, and this returns now is going to carry the details of all the people in custody, including the offenses they committed, their passport, every details about every inmate in the prison. That is the law.
What could be the reason for this?
The reason for this ordinarily is so that the CJ will be in a position, the CJ and the Attorney General rather, will be in a position to know exactly why people are kept in custody, whether such persons are supposed to be there or not. And if anything could be done, because the aim of this law is actually to decongest the prisons and ensure that criminal proceedings are speedily decided.
Now, let's jump to the other part. I'm talking about the first information report, which we're going to dwell a lot on.
Yes.
But we're still also going to look at the part 14, which is enforcing appearance of suspect.
Yes.
But that's going to be later on. But right now, let's look at the first information report. You explain what the first information report is.
Well, the first information report, we are talking about section 110. That's 110. That's 110. That's part 13 precisely of that law. That's the Criminal Justice Law of Abia 2017. He's talking about a situation where, and in fact, that one is very common in our local palace, where people now report cases to the police. And, we have different types of police formations in our environment. Like in Abia, for instance, we have the Zone 9, we have the State ZID, we have divisions, we have police posts. And we know that by this law, such information can come orally or in writing. Okay. And we know that in practice, what we see is that, like from the area command upwards, they don't even accept orally.
It must be written.
It must be in writing. And if it's in writing, this law says that such complaints must be entered into the police crime diary. And it will be the duty of the officer in charge to look at the report, the complaint, so to say, and say whether this report, whether there is a prima facie case, whether it will serve public interest to arrest and prosecute the offender. And they will move ahead to effect the arrest and attendance of such a suspect before a competent court. But the law is that this officer in charge has a duty. The duty is to look at the complaint in the first place. See whether this complaint is worth pursuing. If it's what was pursuing, you go ahead, cause the arrest, or any officer under the officer in charge can be, directed to do the arrest and report back to the officer in charge.
I'm sorry, let me just come in here a little bit. Yeah. Now, based on what you said, when a report is made, whether orally, first of all, if a report is made orally, according to this part of the law, it must be written down. It must be reduced to writing. Yes. It must be written. Yes. And the officer who is in charge of this needs to confirm if this case or this report has enough reason for it to be chased on, to be moved on. That is, if he sees at the end of the day doesn't serve public interest, he might have to. He can back out.
Yeah, he must. Yes, he can back out. He can back out if he finds out that he reasonably believes that there is no case to pursue.
Unlike what we see sometimes where anybody makes a report to the police, you see the police officer just going on to make an arrest, whether it's there is the need for that or not. As long as a report has been made, they move.
That is very wrong. That's very wrong. It's for the police officer to ask questions, make preliminary inquiries from the complainant, find out if they are receiving any reason to go for the arrest in the first place. And if there is reason and he feels he reasonably believes that there is a cause, he cannot cause the arrest of that suspect. But if he finds out there is nothing, he is duty bound to release, by this law, to release that suspect if he's in custody unconditionally. And that ends it. But the law says that he must, remind the complainant of his right to complain to court directly.
If the person making the complaint is not satisfied,
he cannot complain to court directly. Under section 107, can still make his application to a complaint now to court. The court now will now look at it. The court may have a different view that after all an offense is likely or is committed and can also cause either arrest or summons to be issued against that suspect.
All right. Now, moving on. By the way, if you're just tuning in, I'm speaking with Barrister B. Nwachukwu, who is the chairman, Nigerian Bar Association, Acjl branch, and we're looking at advancing access to justice in Abia State through the first information report on that part 12 to 14 of the Acjl 2017. Let's go on and talk about where there's a part that says where the officer is satisfied with no public interest may be served by prosecuting, he may refuse to accept the complaint, provided that he notifies the complainant of his right to complain to the court under section 107, just like you said.
Yes.
Now, it says, notwithstanding the provision of subsection 2 of this section, the officer in charge of a police station may, if in his opinion, the matter might more conveniently be inquired into by an officer in charge of another police station, refer the complaint to such other police station.
Yes, that is correct. A police officer, just like, let's come back down home now. If a case of murder, for instance, is reported to a small police station or a division here, we know that division will not have the capacity to investigate a case of murder. So naturally, that division is duty bound to transfer to homicide section of the CID. And these are the people now empowered with all the facilities and everything to move on with this investigation, because they are the people. Not as if these people are not qualified though, but because these people are now the people authorized by whatever thing they do, they have what it takes to unravel whether an offense of murder is committed or not. So naturally, such a matter will naturally be transferred to homicide section. They cannot move on with the investigation because they don't have what it takes to move on and conclude with it.
Now, 6 of it of Part 13, by section 6 of Part 13 says, after complying with the provisions of subsection 3 of this section, that section 3 says that's the part where it talks about entering it into the police diary.
Yes.
Now, it talks about the officer in charge of the police formation shall act as follows. A, he shall forthwith proceed to the scene and investigate the case as if the suspect is not in custody. So meaning that if the suspect is in custody, he needs to investigate and see if they've not had anyone yet.
Yes. But the problem is that if the person is already in custody, that means somebody must have effected the arrest. Because remember that, don't forget that a complainant can also arrest and bring the suspect. We are not talking within the law here now. You know that even within our laws, a complainant can arrest a suspected criminal and bring to police. And by then, he's already in custody. I think that is what that section is trying to address. Because if he's already in custody, there's no point going to look for him. He can now proceed to the scene, do unnecessary investigation, and proceed to institute a criminal proceedings if they need be.
Another example could be, let's use the example of, where we see someone steal something on the street, and the community there, the persons there, apprehend this person and takes him to the police. The police investigate the matter as if this person is still innocent or hasn't been brought forward.
No, naturally, police should see it as if he's innocent, and ought to ask questions and do the investigation as if, because you must listen to the other party. You must also make further inquiry to find out exactly what these people are saying. It could be a conspiracy. It could be an attempt to lynch him. It could be anything. So the police will see that person, because that's even what our law says ordinarily. He must be seen as being innocent at this point. So the police ought to go in naturally to investigate. It is the conviction of the officer in charge that, see, an offense has been committed. That conviction is the only thing that will make him to proceed to institute. Otherwise, he cannot.
What does the law say in a case where there's a serious injury or someone died in that incident?
Well, if somebody dies in a case like this, when somebody dies, it becomes a homicide matter. It becomes a murder case, and more complicated because life is involved. And remember, the punishment now is death penalty, so it is serious. So police now cannot play with such a matter. And remember, in most cases, it is at the division level that some of these murder cases are reported. And they will naturally go and perfect the arrest, do the necessary things, but they may not have what it takes to carry on the investigation. So transfers must be made to the appropriate, police stations empowered by the law. Or whatever thing they do, as a police unit, whatever, they have their own structure. Police, you see, these people are homicide, these people are this, these people are that. So the appropriate division, the appropriate station must be given the opportunity to investigate the matter as to arrive to the truth.
Now, where someone is injured, the law does say something about the police making sure the person is treated.
Yes. The police is duty bound to, if there's an injury or there is somebody is seriously injured, they can take the person to hospital, ensure that the person is treated, ensure that the person is taken good care of. Not minding whether he's the suspect or whether he's the complainant, or the police duty bound to secure the safety of everybody within the vicinity of a crime scene.
All right. Now, in order to move focus, we're almost out of time. In order to move forward with this part, so we can go into part 14, the other part of the section talk about where the suspect appeared before the magistrate, and the offences are read out to the suspect, and also talks about the fact of the situation where the alleged suspect admits to commission of the offense, or maybe he pleads not guilty to this. So what happens in these situations?
Well, if it is in the magistrate courts, where an suspect is taken to court and he pleads guilty, naturally, a court will convict upon that plea of guilty and punish accordingly. But if the suspect denies the allegation, that is when trial down. That's when the court now is duty bound to give him the opportunity to state why he is saying he's not guilty. The court will move on. That is okay. the person who is saying he committed an offense will be given the opportunity to come there, stay everything that happened, why he feel this man committed the offense, could be cross-examined. Then, when he closes his case, this man now will now come and say, okay, I didn't commit this offense, so this is what happened, this is what happened, and this is what happened. And by the end of the day, the court will weigh the evidence and give judgment. Yes. If he's guilty, automatically he'll be convicted. If it's not, that is the law.
Is there a situation where, because there's somewhere, before we go over to part 14 right now, it says, 7 says, where the suspect appears or is brought before the magistrate court, the particulars of the offense of which he is accused shall be read to him and shall be asked if he has any cause to show why he should not be tried by the magistrate.
Yes.
Could there be a reason why you should not be tried by the magistrate?
Yes. Because the law provides that he may make a choice to say, well, I want to be tried in the high court.
Okay.
I don't want magistrate court to try my matter. And the court, once he says that, I'm talking in practice now, the magistrate will automatically transfer to the high court.
But he must give a good reason.
Well, it doesn't. He may be his personal reason to say, well, I don't want to be tried. I want high court to try my matter. Because that's why in reading out the charges, he will be given the option to choose whether he wants to be tried in the magistrate court or in the high court.
Okay.
And another question, he cannot say, well, gentlemen, magistrate, please, sir, I don't want to be tried here. I want my matter to be tried in the, because that's his choice to choose to choose the court. So it will look as if you have planned everything so that the man will come there and be sentenced.
Okay.
And the court will hands off immediately. And the court can also, if the matter is brought before a court and you don't have what we call jurisdiction, granted, despite that, even under this law, if granted now, let's say an offense is committed at Abia and the suspect is arraigned here in Umuahia, Chief Magistrate Court. This law, under section 99 and 100 of this law, provides that the magistrate can assume jurisdiction if it is convenient for the trial and everything. The magistrate can assume jurisdiction and try the matter as if it has jurisdiction to try cases in Abia. We're talking about magistrate courts now. And if by which this matter is brought and the offender says, well, I don't want to be tried in the high court. I don't want to try in the magistrate court. The court will automatically. But if the magistrate on its own discover that the magistrate has or the court on its own generally, see, I don't have jurisdiction to try this matter, the court can suo motu transfer the matter to the appropriate court. Let's say a matter may be arraigned in Umuahia while it is on high court or magistrate court. This court here can say, well, I have looked at this charge, I have looked at the particulars, I don't have jurisdiction. This matter is hereby transferred to
the high court.
To whatever court that has jurisdiction.
All right. Now, because of time, we've just got about 2 more minutes left in the book. Now, let's talk about part 14, enforcing appearance of suspect. So, briefly, what does this actually talk about?
Well, enforcement has to do with, we're talking about part 14, and that covers section 111 to 113. Is naturally talking about how you can enforce appearance of suspects to court. Of course, we have 3 ways in which somebody's appearance can be compared to court, and that is by issuance of a summons or warrant to appear before a court, summons to appear before a court to answer your questions. Secondly, under section 2, we will now have court can also issue summons or warrant of arrest. This summons can be for your arrest, it can be for your warrant of your arrest. Arrest him and bring him. You can direct the police, can direct any person, can direct the IGP, can direct DSS. Arrest also person and bring him before this court for trial. Then, the last one is when a person believes reasonably that a crime has been, that an offense has been committed by a person and he brings a complaint. You can do that. You can compel, like now, my attendance to court by raising a complaint against me before a court. Before a court. You can go to court directly. I'm not talking about police. I'm not talking about, you can go to court directly and apply that an offense has been committed. Upon that application, you can compare my appearance before that court.
I wish we had more time to talk about all this. Anyways, thank you very much. Anyways, we'll have to come to the end because we are out of time. Each time we talk about this, time runs very fast. But I want to say thank you very much to Barrister B.A. Unwachiku, Chairman, Nigerian Bar Association, Isialangwa branch. We've come to the end of today's edition of Wheel of Justice. Don't forget, it comes your way every Tuesday from 3:30 p.m. And it's brought to you by the Abia State Administration of Criminal Justice Monitoring Committee and Prisoner Rehabilitation and Welfare Action, Prawa. By the way, Kelechi Imo is here. It's good to see him again. He is representing Prawa right here. And also, a big thank you to the Open Society Initiative for West Africa, OCWA, who are partners in this, and also the Abia State Justice Reform Team. My name remains Ifeanyi. Till next week, make sure that you stay safe and always follow the laws of the land. Bye for now.